Good morning, everybody. It is Tuesday, July 6th, and this is our morning drive live. So hopefully everybody had a enjoyable and relaxing holiday weekend. It was a long weekend for us. In my office, we were off yesterday, mainly because all the insurance companies were closed and there wasn't a whole heck of a lot we could do. So we took off to observe July 4th on July 5th because that's the observed holiday. Hopefully, everybody else had a wonderful weekend, got some excellent relaxed time in because that is important. But I want to talk today about the OSHA ETS, the Emergency Temporary Standard. There's been a lot of discussion over the weekend. I didn't really chime in too much over the weekend because I was trying to unplug and relax, and my son was home from college, so spend as much time with him as I possibly could over the weekend. But now we're back and we're ready to talk about it and hopefully clear up some confusion. So, the Emergency Temporary Standard is OSHA's emergency reply to COVID-19 and to the long-term effects that it will have on not only dental offices, but medical offices as well, hospitals, all medical facilities. And basically what they are saying, as far as the patients go, they are not talking about masking because OSHA has nothing to do with the patients. What they are talking about is the employees. And that is something that is important to remember, is that OSHA rules only apply to employees. They do not apply to patients. However, you go by your local ruling when it comes to patients. But for employees, it is very important that you follow the ETS if it applies to your office. Now, there were a lot of posts over the weekend saying, well, our state says we don't have to do this. Our state says we don't have to do this. Our state dental board is saying we don't have to screen or we don't have to do this. However, what you have to remember is the ETS is federal law. So states are allowed to have a more strict law, but they cannot have a less strict law, which means federal ETS applies for every single state, all 50 states, unless your state has a stricter law, all of the rules apply. So, here's what we're going to say about that. If you are no longer screening your patients, temperature checked, pre-walk in the door questionnaires, then the ETS applies to your office in full. If you are a dental office and you are screening all non-employee visitors, okay, that is very important. That's a very important part to this. Non-employee visitors, sales reps, plumbers, HVAC technicians, IT people, anyone who walks into your office, if you are not screening them, pre-entry screening, then the ETS, the Emergency Temporary Standard, applies to your office. If you are screening them and documenting the screening for every non-employee visitor, that includes patients. It also includes the list I just gave 30 seconds ago. If you are screening, temperature checks, questionnaires, and refusing any entry to anyone with signs or symptoms suspected COVID, or confirmed COVID. If you are not turning them away, then the ETS applies to you. The ETS is a 529-page document that talks about mask requirements, N95 requirements, who's required to wear a mask, in what areas are they required to wear a mask. There is a difference between how you are treating vaccinated and unvaccinated employees. So it's all coming into play now within the emergency temporary standard. All of the vaccine talk, they're not saying you have to have the vaccine, but they are saying if you don't have it, the mask requirements in office will continue. So, if you are an unvaccinated employee in an office where the ETS applies because you are not screening non-employee visitors, patients, IT, plumbers, et cetera, then you have to be masked. You cannot eat lunch in the office anymore because you have to be masked when you're in the office. Again, that's just unvaccinated employees. Vaccinated employees are able to congregate in a break room, unmasked, eat, so on and so forth. Unvaccinated employees are not. So there becomes a difference in how we treat people based on their vaccination status if the ETS applies to you. If you are continuing to screen, temperature check, and document all non-employee visitors, then the emergency technical standard does not apply to you. And again, I want to make it very, very clear. It does not matter what your state law says on this if it is not more strict. And by more strict, I mean more protective of the employee as far as mask wearing, as far as all the other rules in the 529 pages of the ETS. If it is not more strict, then you follow the federal OSHA guidelines. Remember, OSHA applies in all 50 states. There are some states that have their own OSHA plans. There are some that do not, but you have to follow the stricter law. If your state says, nope, you can open up and everything is fine, and you don't have to worry about screening patients, you don't have to worry about that anymore. The federal law says you do, and you follow the stricter of the two, and the stricter of the two says you do have to do it. So I'm going to post a link again, just like I did last week, to the ETS. Again, it's 529 pages, but you have to go through the flow chart first, know whether it applies to you or not. In a dental office, it's real simple. Are you pre-screening all non-employee people walking into the office, documenting temperature checks and questionnaire? If you are not, the ETS applies. Are you turning away people who have COVID or you suspect of having COVID? If you are not, the ETS applies. So very, very important. Look at that. Know if it applies to you, because no matter what your state says, you still have to follow the stricter rule. And the stricter rule as of right now in all 50 states is the ETS. So pay attention to that. Know what you're doing, because this is going to be a big thing. Listen, and I hate to say this, the federal government needs money right now. The quickest way to do that is to walk into every dental office in the country and ask if you're following the ETS. I guarantee you 80% of them won't even know it exists. So hopefully everybody here knows it exists. Follow the link, look at the ETS. We are going to do a webinar later this week. It's taken a while to get it all together, but we are going to have a full webinar on the ETS later on this week. So just so everybody's prepared. I am here. Everybody have a great Monday, and I will see, oh, wow, it's Tuesday, even though it feels like Monday. Everybody have a great Tuesday, and I will see you guys tomorrow. Good morning, everybody. It is Wednesday, July 7th. and this is our morning drive live. So, today I want to I want to cure some of the misconceptions everybody is having, and some of the things people don't understand about the Cures Act. The Cures Act went into place in its initial phase on April 5th of 2021 and is primarily about what's called information blocking. Information blocking is just what it sounds like it is, which is providers blocking information to their patients. So, blocking their patients' access to that information. I want to kind of set the record straight on a few things here. Number one, it applies only to information that is stored electronically. So, any information that is stored electronically for your patients is what the Cures Act applies to. If you still have paper charts and you only use paper charts, then the information does not apply. Where the confusion comes into play is for offices that use paper charts but also submit claims electronically, so ledgers are stored electronically, x-rays are stored electronically, but you're still using paper charts. The problem is now your patients have mixed access. So you'll have patients who you're required to provide timely access to all of the information stored electronically, which would be their ledgers. That would be, let's say you scan letters from specialists, from the orthodontist, from the oral surgeon. You scan those into your practice management software. The patients now will have access to those, but your chart notes are not electronic. That's fine, then they don't have access to those chart notes because they are not stored electronically, but you'll still have to provide access to all of the information that is stored electronically. Now, I said at the beginning, it's a multi-phase rollout. And, what it seems, and it may be partially my fault, but what it seems everybody got caught up on or got stuck on was providing those patient portals to the patients to access that information, to access those records. And yes, that is part of the Cures Act. It's not the only part of the Cures Act, but it is part of it. The enforcement for that part of it doesn't begin until 2022. So we have another, 6 months still until that part of it goes into play. However, the providers of the software, so Patterson, Eaglesoft, Dentrix, Henry Schein, Open Dental, they are the ones who right now are working at what I am sure is a feverish pace to get the patient portals set up and accessible. They are the ones who have to provide the access to the information. You are the one who has to be sure you're using a software that provides access to the information. You don't have to build your own portal. You just have to make sure the record management system, the Eaglesoft, the Dentrix, the Open Dental, the Curve, that the one you're using has the capability to do so. That's the issue. So you don't, again, a dental office itself does not have to worry about programming an API connection, about creating a patient portal just custom for their own patients. Some larger facilities absolutely do that. The health system with the hospital and the doctors and everybody that I go to personally, they have their own because they're huge. They're $1 billion a year corporation, and they have their own. A dental office is not expected to build their own portal, but you are expected, as of 2022, to use a software that does allow or does provide for patient portal or app access to the patient's records for the patients. So, I don't want anybody to get worried, get freaked out about that. There is going to be, towards the end of this year, a lot of suppliers who will be able to provide that patient portal, will be able to get you that access. So if Patterson decides, hey, we're not going to offer this through EagleSoft, I am sure you'll be able to find it through RevenueWell or Modento or some other third-party connection will be able to provide that patient portal to you, and that's the key. You don't have to design your own, you just have to have one. So that's going to be the key for this whole thing. Now, the other part of the Cures Act, and really in my mind, it is the more important part of the Cures Act, comes down to how quickly you are releasing records when patients ask. This part of the Cures Act went into effect April 5th. It is in effect now. And basically, it doesn't override HIPAA, but it increases patients' access to their records by doing away with the 30-day federal timeline that we have. Some states have a 10-day, some states have a 14, some follow the federal guideline of 30 days from the request to release a patient's records. What the ONC says, what the Cures Act says, and again, this part went into effect on April 5th, is that you have to provide access to patient records as quickly as possible. So they did away with the 30-day, and now it's as quickly as possible. If you can provide it same day, you do. If you can provide it in 1 or 2 or 3 days, that's what you do. Because no more is I have 30 days, I can take forever to send these records. So that is a huge thing. They haven't addressed the fees yet, but we already know federally under HIPAA, if you're replicating fees, you can charge either your actual cost or you can charge $6.50 flat. We already know that. You cannot just charge $10 per page. You cannot charge a flat fee of $100, whatever it is. You have to charge your actual cost of duplication. There can be no research fees. There can be no search fees. There can be no retrieval fees. It's actual cost of duplication. And who really wants to sit and figure out how much it costs you to print a page of paper? Or $6.50. They haven't addressed that yet. However, next year, 2022, when the patient portal access part of it kicks in, that has to be provided to the patients at no cost. So they will have electronic access to their records at no cost. And, for now, if you're duplicating records, then you charge actual cost of duplication. So, and if you're emailing them, your cost of duplication is $0. So actual cost of duplication or a flat fee of $6.50 per record per patient, because their entire record is included in that. So hopefully that clears up some concern people are having about it. You do not have to rush out and hire a programmer and build your own patient portal. There will be a ton of providers ready to offer that when the time comes. So hopefully that clears it up. Everybody have a great day. I am here, and I will see you guys tomorrow. Good morning, everybody. It is Thursday, July 8th, and this is our morning drive live. I want to talk today about temporary doctors, fill-in doctors, doctors coming in to cover vacations, doctors coming in to cover maternity leaves or, FMLA leaves, medical leaves for your docs or associates or owners or whoever. Anytime a doctor is coming into your office to temporarily fill in for the normal doctor in the office, there's a process to this that we have to follow. First and foremost, let me start by saying, I've seen a lot of posts over the past 2 days in a number of groups, actually. I guess because summer is coming, or, who knows. Um, but a lot of posts asking, can we just continue to bill under our doctor? Can we just continue to bill under the way we always do and send the claims out that way? And just that's what we do. It's just a different doctor treating the patient, but the claim form goes out the same as it always has. And the answer to that question is no. That is the very definition of insurance fraud, is providing any false information on a claim. And if the treating doctor is not the treating doctor that's listed on your claim form, every single claim you send out is fraudulent. And, technically, they're all crimes. And, those crimes start to add up because if you send a claim electronically, it's wire fraud. If you get paid via a check that is mailed, it's postal fraud. There are a number, because you're using the post office to commit fraud by getting that payment. So there's a number of reasons not to do it. But, first and foremost is it's totally and completely illegal. You're providing false information on a claim form, and you cannot do that. If you're knowingly putting false information on a claim, you are committing insurance fraud. Now that that's over, there's a couple ways to deal with this. Number one, if it's something that you have lots and lots of notice for, you can try and get that temporary doctor credentialed. Now, if it's a maternity leave and they're going to be covering for, 6 to 8 weeks, it's probably not worth it to go through the credentialing process that can take 2, 3, 4, 6, 8 months for, a 6 to 8 week coverage. But what you can do, and this still can take anywhere from 2 to 6 weeks to get done, is set up a locum tenens. A lot of insurance companies, not all of them, but the majority of insurance companies recognize a locum tenens. And that just means that a doctor is coming in to fill in your practice for a temporary coverage. A locum tenens would not be we're hiring a new associate who's going to practice in the office. That person would have to be credentialed. But locum tenens is a temporary coverage. And while it does take some time to get done, depending on the insurance company, that is the proper way to do it. That tells them that this other doctor is covering on a temporary basis for your doctor, for whoever the normal provider is in your office, and that makes them in network utilizing your current doctor's contract, your current doctor's agreement. just for the time period that they are specified for. Locum tenens are very specific. So if you're doing it to cover your doctor is taking a 4-week vacation to go to Europe, you would do it for those 4 weeks. If it's a maternity leave or paternity leave, you would do it for that 6 to 8 weeks that they're going to be out. I usually give a week before and a week after just to make sure we're covered in case of any kind of emergency or any early deliveries or late deliveries, whatever it may be. But I usually go a week before, a week after, just to add those extra 2 weeks on. But you can reach out to the provider relations department of every insurance company, just about, to create a locum tenens agreement. Submit the application. Yes, you will need to know who that temporary doctor is. You will need their NPI. This is not something that you can do last minute. Okay, so it's not, our doctor fell and got hurt, God forbid, Dr. Felon got hurt and is going to be out for 8 weeks. Let's get somebody in here temporary just to cover starting next week. It's not going to be that quick. Depending on the insurance company, it's going to take 2, 4, 6, 8 weeks to get this done. So yes, you have to start the process early, but it's worth it because you can then submit under that treating provider on the claim form, and they will still be recognized under your current doctor's contract. And that's what you're looking for. If you don't do that, you bill out without a locum tenens, without the temporary doc being credentialed through your office. You're going to bill out that temp doc as the treating provider. You're going to bill out either your type 2 or your owner doctor as the billing entity on the claim form. So the payments are going to come to the billing entity, but the provider will be the treating provider on the claim form. And that's the only legal way to do it. That is the right way to do it, is to do a locum tenens. If it's an emergency situation, you can't. You bill it out the way it is with the temp doc as the treating provider, your office or the owner doc as the billing entity, and that temp doc is going to be out of network. Your patients are going to have to pay out of network, or the other thing you can do is adjust your fees on every single claim form to your allowed fees. You can do that. As long as you're telling the insurance company that's what you're doing, you can do that. So hopefully that clears everything up. It makes sense for everybody who had a question about it. Get a locum tenens, start in advance, go from there, and you should be okay. If you don't have time to do that, there's nothing else you can do. You're absolutely going to have that treating doctor out of network. So I am here. Everybody have a great day, and I will see you guys tomorrow. Good morning, everybody. It is Friday, July 9th, and this is our morning drive live. There has been, over the past few days, a lot of posts about hiring, about hourly rates, about people being brought into the office and hired today at the same or even a higher rate than what current employees are being paid. And a lot of people have been saying, know your worth and know that people new people being hired shouldn't be being paid the same as people who have been there for 2 years or 3 years or 4 years. And I just want to put out there how we do things in my office and in my clients' offices that I consult for, that I manage. And I can tell you, it may not be something that a lot of you like, but it's the reality of life. I don't pay people based on seniority. I don't pay people based on how long they've worked for me. I pay people based on what they are worth to my business. Okay, I don't do promotions because, well, you've been here the longest, so you get to be the manager. My billing department manager, the person who manages my entire remote billing department for my company, because we do remote billing services. That's one of the services that my company provides. The person who manages that department isn't the person who's been there the longest. It's the person who I felt would do the best job in that role, regardless of seniority. Seniority to me means absolutely nothing. I appreciate loyalty, and loyalty is one of the factors that is rewarded. However, I don't give promotions and I don't give pay raises based on how long you've worked for me. I do them based on what your value is to the company. So, what you need to look at, and again, this is my opinion, it may not be right for everybody, and that's okay. But what I look at when an employee comes to me and says, I want to raise, is what makes you worth more now than you were 6 months ago? Have you learned new skills? Have you increased my collections? Have you taken on more responsibility? There has to be something that makes you worth more. And the fact that you sat in the office for 6 months longer than somebody else doesn't count. That sharing the air in the office for a specific amount of time shouldn't guarantee you that you're worth more money. Again, there is something to be said for loyalty and for being there. But in my mind, loyalty doesn't mean I will be loyal to you as long as you pay me more. Those two don't match up. One doesn't equate to the other. So, coming to your boss and asking for a raise, I think is something everybody should do. It should be a normal discussion. However, it it shouldn't just be, I've been here for 2 years, and I think I deserve a raise because I've been here for 2 years. What have you learned? What have you done in the past 2 years to become more valuable to your company, to the business? If the answer is nothing, you've done nothing to become more valuable, you have the same skill set, you do the same amount of work, you produce the same amount for the company, whether you're a hygienist or an assistant or somebody at the front desk. If everything else has stayed the same and you expect to be paid more, that's not realistic. The company has to grow in order for you to be paid more. And, part of that is what you're doing for the company to help the company grow. So if you want to be worth more, learn more, expand your skill set, expand your knowledge base, take on more responsibility. That makes you worth more, which then makes the I want to raise conversation that much easier, because now you can, with numbers, prove that you are worth more. If you just say, I think I'm worth more, why? Well, because I think I'm worth more. Because the hiring market is harder. The hiring market is opening back up. And what I'm afraid is going to happen is all of these people who got hired at very high rates because it was so difficult to find employees are going to find themselves being laid off or being terminated, because now I can hire somebody if I hired a new person at $20 an hour because I had no choice, because I needed a body and we couldn't find people because of the state of the country, because of the whatever reasons they were, you couldn't find people. All those people now, as the employment market opens up and more people are re-entering the workforce, if I can hire somebody at $15 or $16 an hour instead of paying you your 20 that I had to pay you when I hired you, 6 months or 8 months ago, all those, I won't say overpaid, but higher paid people are going to be let go. They're going to be laid off. They're going to be terminated because I can replace you with somebody that's going to save me $200, $300, $400 a week. So, that's definitely something to think about. Everybody should absolutely know their value, but be prepared to present why you are worth more than that. And just because I'm a warm body that shows up every day doesn't equate to you're worth more. Show your boss in concrete numbers why you're worth more. What responsibility have you taken on that you didn't have 6 months ago that you now have that makes you worth more? What skills have you learned in the past 6 to 12 months that make you worth more than you were 6 to 12 months ago? That's the important part. That's what we can do to help grow our own careers and further our income. So, I know this isn't going to be a popular opinion, but it's the way it is. It's reality. A business can't just produce the same amount and pay people more. So, hopefully that makes sense to people. You understand. I'm not saying you're not worth more. I'm saying know why you are more. That's the important thing. It's Friday. Everybody have a great weekend. I am here, and I will see you guys on Monday morning.